going to talk about, trying to come back to this failure to complete phase 1, Texas Family Code step-up visitation for children under the age of 3. Then we got to, again, me fully complying with all of that, him not even scheduling his full 4 hours, and then all of a sudden, again, just in retaliation of all the pending contempt and protective order, the groundless frivolous suit to harass a party. That's actually a legal term. That's not just my language. If you look it up in the Texas Family Code, it talks about groundless frivolous suit to harass a party via motion to modify for possession and access. And of course, again, just the last tool in abusers' toolbox to continue to maintain power and control of the victim. Then we've got the next step of unlawful, construed by fraud, violation of due process, no subject matter jurisdiction, void temporary order issuance. That actually took place on October 2nd, 2015 in Emily Miskull's 470th Court. You'll see that the court docket stated that mother did not appear. Of course, that is a complete fabrication where the court actually erased the email where I was asking for Texas Victims' Rights safety and escort, safe waiting area information. Of course, she left that out of her chain. We'll get into that later. And so the court completely committed fraud, and they also violated the procedure in even being able to enter that default judgment. There was not a return of service on file for 10 days, and that's a requirement under Civil Practice and Remedies Code. So that judgment should have been set aside, but of course, judges don't have to abide by the law, apparently, in Collin County because they're above the law, or at least the judges I've dealt with. All right, so then we get to where they have this order. I actually do start complying with it until circumstances, material and substantial changes start occurring with regards to, getting medical advice not to allow force feeding. It was stated, and I do have this audio, that it could cause food problems for her for life, as well as behavioral issues. And so I was actually told to seek court intervention and not allow her force feeding. Again, I tried to do that on 10/30. Of course, my right to be heard on that emergency filing was denied. And so ultimately, I finally got to the point after, again, I've been the only one abiding by the law. You got people that have been practicing law 35 years. Again, judges that are supposed to be at the higher standard of law, court coordinators, district clerks, that know the law but aren't abiding by it. I finally got to the place where, again, you know what, my daughter's safety comes first. I'm not going to let them continue to court sanction another one of my children to abuse and or neglect. And so I just stopped taking her, also knowing that this was a void order. We're going to talk about the law of voids here soon. And also I proved it in my case. And so they move forward with enforcement of possession and access, wanting to fine me, wanting to have community supervision, wanting to imprison me for 18 months per count. Originally there was 2 counts, that would have been 36 months. And so they tried to have a hearing, again, violating due process. I cited the proper code to make sure that that hearing didn't happen and requested an attorney. I was not actually advised that I had the right to an attorney, which is another thing that the judge is supposed to do. The family law specialist, Emily Miskull, so of course she knows that, but she didn't do it. I did have to ask for one, and I was appointed a court-appointed attorney. Now, what I didn't know was this was a buddy of Judge Emily Miskull, Brooke Folks, and this is where now we get into Brooke Folks working with the judge, opposing counsel, the court coordinator, the court law enforcement officers, this is her bailiff, court clerks, to obstruct, collude, and prejudice my case. Then we go into the void unlawful order to modify parent-child relationship. That was actually finally signed and entered on March 2nd of 2016. So here just about a month and a half ago, the original order was actually entered per a 470-52517-2014, which is our original cause number. Rulings of the court is what it was entitled. It was just simply a memorandum, and we'll get to that later. But ultimately, it was a final void unlawful order to modify parent-child relationship. Why was it void? Well, of course, we just skipped all the prerequisites. Ken Harder in his pleading said that we should have a Schedule 3 discovery control plan. Every case is to be managed by a discovery control plan. And we did not have a level 3 ever signed, so we completely skipped that process. And there's other prerequisites to having a final hearing. There was no mediation on the case, so many various different things. My right to jury trial, of course, was circumvented and stolen by the court-appointed attorney. But then we get to avoid unlawful suspension of commitment to jail for 14 days on the legally void order for contempt of possession access. Then we get to the legally void 2 weeks of makeup visitation time to be with her father from February 9th to February 24th. And then unfortunately we get to what seems to be pretty darn clear, and I've been asking them to refute it, which would be definitely signs of sexual abuse and bona fide physical neglect and not treatment of the 23-month-old toddler, which is my baby girl. And then me trying to file and have a hearing so we could just discuss it. But for some reason, I don't know why, if they don't have anything to hide, they could not have that hearing, couldn't agree to schedule it, and then use 7 people: the judge, her bailiff, her court coordinator, Mallory Maddox, and then 3 district clerk family law supervisors: Stephen Janway, Zonia Manjarez, Cindy Watson, and Christy, although I believe she's completely innocent. She was the clerk that Stephen Janway and Zonia Manjarez stood behind to make sure she did not file my TRO prior to the 3-2 hearing. Then we're going to talk about when I filed a request for findings of fact and conclusion of law regarding that February 9th final hearing, and also the ruling that was the rulings of the court. Then we get to, in between that time, of course, still TRO denial and motion to modify, filing refusal before that 3-2 hearing. The 3-2 motion to enter hearing, if we had heard the evidence of physical neglect, of course the judge would have had to protect the child. They didn't want to do that. They'd already decided he was going to get custody, and he knew it. You'll hear a recording where he knew. You're the criminal, I'm not. They're going to give the child to me anyways. So then, of course, again, we've got the final order issuance. Then we have immediately, I filed a motion for new trial on the modification and contempt of possession and access to extend my appeal deadlines and to give the court another opportunity to correct themselves. Then they don't do that, and the final hearing, she actually changed her order from what was ordered in the rulings of the court to say that somehow what he pled for, with me still as the parent with the right, the primary right to establish residence, she actually put in the order that he is to have her Thursday night, and that's supposed to go all the way through Monday. So that would mean Thursday night, Friday night, Saturday night, Sunday night, go all the way through Monday every single week. But then, of course, she states first, third, and fifth weekend. So the order in and of itself contradicts itself. I did bring this up on the record, and I discussed how this was not pled for in any of the pleadings by Kenneth Harder, how this was not discussed at the hearing, how this definitely was not ordered. And ultimately, Emily Miskell said, well, that's what he meant, so that's what he's getting. So she ultimately changed the substantial nature of the order in this 3-2 final orders hearing. And so that gave me authorization and the ability to file a new request for findings of fact and conclusion of law within 10 days, which I did. And that's actually where now we go ahead and we enter into these illegal arrest attempts to revoke, void suspension of commitment, the failure to appear warrant, alleged failure to appear warrant, and then, of course, now the illegal kidnapping attempt of the court-sanctioned abused and neglected toddler via void writ of attachment for the body of the child via Texas law enforcement officers. She's not happy, so I'm going to wrap this up. Thanks for checking out all the many steps that we've gone through from August of 2015 to get to where we are today. Thanks. All right, princess.